Yo, 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 Jonathan Pollard, Fort Lauderdale employment lawyer. Today's topic, retaliation. Okay, so I'm just going to spit on this one. Retaliation is defined as the company taking a materially adverse employment action against an employee who engages in protected activity. Let's unpack that, okay? And let's start with the protected activity piece, because that's where all of this flows from. When we say protected activity, what we're talking about is raising a complaint, a concern, a grievance about something that is unlawful. Retaliation gets somewhat complicated because there are a variety of different laws or statutes at issue, and there are specific retaliation claims for each particular statute. So for instance, Title VII, okay? And I do talk a lot of trash on Title VII. I'm not the biggest Title VII fan because there are damages caps that were passed in 1991 and have not been updated since then in spite of inflation, cost of living, et cetera, et cetera. Basically corporate welfare, right? So there's Title VII. Title VII is the main employment discrimination law. If you claim that you are being discriminated against on the basis of sex, right? You say, I'm a woman, I'm being discriminated against based on the fact that I'm a woman, I'm being treated differently, I'm not being given the same opportunities, the same resources, the same training, etc. And the company turns around and promptly fires you, right? Textbook retaliation claim of the Title VII variety. But retaliation is not just limited to or confined to Title VII. There are specific retaliation provisions, or retaliation has been recognized under a variety of different statutes. My favorite retaliation cases right now, 1981, 42 USC 1981, the original Civil Rights Act, okay? The reason why I like 1981 as opposed to Title VII is because 1981 does not have any damages caps whatsoever. There are no limits to the compensatory or punitive damages that you can get. Yes, on the back end of trial, the judge might reduce the verdict, if it's something truly extraordinary, if it's $100, $200 million, but technically speaking, there are no damage caps. Under Title VII, you're capped at $300,000, no matter how egregious the conduct. And, bluntly stated, that's just not enough money. To big companies, insurance carriers, corporate defendants, that's just peanuts. They don't care about $300,000. That's why I prefer to pursue 1981 claims where there are no damages caps. So retaliation under 1981 applies to what? Race discrimination. So if you raise a complaint or concern about race discrimination and you were subsequently hit with an adverse employment action, let's talk through that, okay? A lot of folks contact our office every day with various plaintiff side employment cases, and many of these cases go in the direction of petty interpersonal bullshit, okay? So-and-so was mean to you. So-and-so didn't value your input. You felt like your voice wasn't heard. You're being targeted and put on a PIP plan. Like, none of these things actually have legal meaning or ramifications. When we talk about retaliation, we are not talking about someone was mean to you, someone was passive aggressive to you, someone ignored you, someone didn't invite you to the break room for cupcakes for Julie's birthday party, right? That's not what we're talking about. When we talk about retaliation, we are talking a material adverse employment action, such as, number one, you were fired, right? That is the most textbook, unimpeachable retaliation claim possible. You report race discrimination, gender discrimination, unequal pay, not being paid overtime wages. You file a workers' comp claim, right? All these things that I'm mentioning here, they are forms of protected activity, right? Raising a particular complaint or concern or grievance. I like the race ones for a variety of reasons, but from a business standpoint, I like them because there are no damages caps under 1981. Those cases are savage. I will also mess with the FLSA unpaid overtime ones, right? You see this all the time. Companies exploit poor people. You have a poor person working a job that's primarily manual labor, working overtime, not being paid for it, goes to the powers that be and says, I'm working 65 hours a week, and I really think that under the law, I'm supposed to be paid overtime. Bam, the company fires him, right? That's retaliation, and I will mess with that. You don't get punitive damages on those in the 11th Circuit, but there is a circuit split. There are some circuits where you can get punitive damages, but in any circuit, you can get compensatory damages, and there are no caps on the compensatory damages. There's just a lot of judicial activism, right, pushing back against that. And I'm allowed to say that, right? I'm still an American in this country, right? I still believe I have a First Amendment right to say what I think about the law and the system and courts and everything else. And there is a tremendous amount of judicial activism out there. There are a lot of judges who don't want plaintiffs in these cases making more money than the economic damages or wages at issue, right? And all of that funnels in the direction of courts trying to make damages for emotional distress, loss of dignity, humiliation, embarrassment, make those somehow tied to or attached to the wages at issue. And if somebody's making $13 an hour, there's this artificial notion that somehow, wait for it, their dignity is worth less, right? Wow, how regressive is that? How messed up is that? I have to out myself, people. Like, I don't believe in the system. I think the system is dysfunctional and in some instances nakedly corrupt. And I'm basically here to go at the system and take money from big companies, insurance carriers, and corporate defendants. That's right. You caught me, right? You caught the tater, okay? So the bottom line there is you have a materially adverse employment action. And the most textbook is termination. What else do we see a lot of? We see hours reduction, right? Cutting hours for hourly employees, factories, manual labor, construction, right? Retail, somebody complains about, i.e. discrimination, and then subsequently they go from working 38 hours to only being on the schedule for 20 hours a week, right? And it happens immediately on the back end of the protected activity, the complaint about something unlawful, right? That's another textbook retaliation case that we will mess with. Demotion, you see that sometimes. Reduction in salary, you rarely see that. Reduction in salary is one of those things where, just in a business sense, it's almost assumed that if you hire someone and you pay them X, it's very difficult to reduce their salary below X. So we don't see a lot of that in the retaliation space. We do see termination, reduction in hours, reassignment to a less favorable position, and finally a negative change in their work conditions. But that can't just be petty interpersonal shit. That has to be something like you work in a manual labor role and you are normally on a team of 3 people because the labor is very physically taxing. You complain about discrimination, and a couple days later, you are on a team of 1 and tasked with completing the same output or degree of productivity. That's the kind of thing we're talking about. We are not talking about somebody got in your feelings and didn't hear your truth and you did not get invited to the breakfast social, and you feel that that was directly attributable to you raising your grievances. Bottom line, if you feel that you may have a retaliation case, you are welcome to contact our Fort Lauderdale office. We will evaluate your case at no charge. We reject 98% of cases that come across our desk. But if we do evaluate your case and determine that we think it is viable, we will give you zealous, aggressive representation, and we will take the case as far as you are willing to go. Jonathan Pollard, thanks for watching. Have a good day.